Be ready for dictation. 5 seconds. Start. Sri R.C. Saxena, learned counsel for the petitioner, drew our attention to Rule 59A of Financial Handbook, Volume 3, which provides that a delinquent official, if posted at a place other than the place of inquiry, he shall be entitled to travelling allowance for attending the inquiry, except in the cases where he himself has got inquiry transferred to some other place. On the basis of said rule, it is submitted on behalf of the petitioner that since he was not paid any travelling allowance, as such it cannot be said that he did not cooperate in the inquiry by not attending the same. After going through the said rule, we have examined the matter from that angle also, and we see no force in the contention of the petitioner. The said Rule 59A does not provide to send advance payment of travelling allowance to the delinquent official. What the petitioner should have done is that he could have attended the inquiry and thereafter a travelling allowance bill should have been submitted to the concerned department. But the record shows that even after being given several opportunities, the petitioner never attended the inquiry and was rightly held guilty of the charge of unauthorized absence by the inquiry officer. Firstly, the petitioner himself is at fault by not making said representation within the time allowed and by not presenting himself before the authority concerned. Secondly, if the representation by post reaches after the impugned order was passed, it cannot be said if the concerned authority was bound to consider the said representation. Otherwise also, even on consideration of the representation of the petitioner, the fate of the case would not have been different, for the reason that he has conducted himself in such a manner by not reporting to duty for several years with lame excuses that the department could not have passed the order except the one passed. Also, this court cannot ignore the fact that admittedly the petitioner is still facing two serious charges of offence punishable under section 409 of Indian Penal Code in the courts. In that background of fact, misconduct of the unauthorized absence for several years by a member of disciplined force makes us feel that it does not warrant any interference with the impugned order of the State Public Service Tribunal, Lucknow, which dismissed the claim of the petitioner for detailed reasons mentioned in the impugned order. Before parting with the judgment, we feel it necessary to add that the learned tribunal, while dismissing the claim petition, has considered and discussed at length all the points raised by the petitioner. It has been categorically found by the tribunal that though the petitioner has alleged that he was not given copy of preliminary inquiry report, but the same was found to have been sent to him. It is further mentioned in the impugned judgment that not only the petitioner was given necessary documents with charge sheet, but also the notices inviting him to cross-examine the witnesses. The reasons are harbinger between the mind of the maker of the order to the controversy in question and the decision or conclusion arrived at. They also exclude the chances to reach arbitrary, whimsical or capricious decision or conclusion. The reasons assure an inbuilt support to the conclusion / decision reached. The petitioner failed to attend the inquiry despite multiple opportunities, citing non-payment of travelling allowance under Rule 59A of Financial Handbook, Volume 3. However, the rule doesn't mandate advance payment. His prolonged unauthorized absence and pending criminal charges justify the disciplinary action. The tribunal rightly dismissed the claim, providing detailed reasons to prevent arbitrary or biased conclusions. Stop.